So here, if we go into the next question, 4C, when does a check become non-negotiable? So before going into this question in detail, let us know few other terms. So I will not explain you these terms in detail because I am just referring to the sections and I am giving you these sections so that you could go through and check it once. So if you go through chapter 14 of Negotiable Instruments Act, under sections 123, 124 and 130. So this chapter talks about crossed checks. Crossed checks. 123 is about general crossing. 124 special crossing. And 130 is a check bearing not negotiable. And this is what the question is about. When does a check become non-negotiable? So before that, you need to understand the types of crossing under 123, 124 and 130. Look into these sections explanation part. So now if we go into the question, a check will not become non-negotiable as long as it is issued perfectly and signed. So it will not become non-negotiable unless it is so perfect. So it will not become non-negotiable if it is properly issued, signed and payable. But there are certain conditions where a check is treated as non-negotiable. That is stale check. After 6 months, after the period of expiry, it will be considered as not negotiable. Post-dated check. Suppose if a check is having a future date, so until that period, the post-dated check will be treated as non-negotiable. And the other one is crossed check. Crossed check. So under section 130, which is written as a check with non-negotiable. So if it is crossed with two parallel lines and has written the words that not negotiable, then that check will be not deposited into any of the payee's bank and it will be treated as not negotiable. So there is other scenario in which it is treated as not negotiable, like due to insufficient funds, the check can be treated as not negotiable. If it is a lost or stolen check, then also the check is treated as non-negotiable. So these are certain conditions under which a check becomes non-negotiable. So now we will go into the next question, which is question number 4D. So here it is written, a check issued by a company is dishonored. Okay. So a check is dishonored which is issued by a company for lack of funds. In what circumstances can the directors of the company be prosecuted under section 138 of Negotiable Instruments of Act? So here they are asking, under section 138 of Negotiable Instruments Act, under what circumstances a company can be prosecuted for dishonor of check. So here a company means a body corporate which includes firm or any other association of individuals. And a company is treated as an individual person. So an entity or a company is treated as an individual person. And who is a director? So just to know. So here we are talking about company and director. So who is a director? A director is in relation to a firm, means a partner in the firm. So these two terms are explained under explanation in section 141 of NI Act. So section 141 of NI Act says about offence by companies. Offence by companies. So as per this section, what it states is, if any person is committing an offence under section 138 of Negotiable Instrument Act, whether it be a company as a whole or any person in charge of the company or some defined dignitaries or some signed authorities who are conducting such business or who are responsible for the business of the company, these people shall be treated as guilty if it is proved under section 138 of Negotiable Instrument Act, which is nothing but a dishonor of check. So all these people will be treated as guilty if it is proved that a company is dishonored for the lack of funds under section 138 of NI Act. So provided with this, these people cannot be punishable. So this will be treated as an exception. So whoever the persons or the people which I talked about earlier, so they cannot be punishable if it is proved that without their knowledge, the check has been issued, or even after conducting all the necessary due diligence in the company, still there is a dishonor of check. So under these two circumstances, they can be taken as an exception to prove them under guilty. So after this, there is one more thing to remember, provided which if a person who is nominated as a director of the company, he is holding the company by virtue of any of the office of employment in central government or state government or the financial corporation which is controlled by state and central government, as this case, then this director, he shall not be prosecuted under this chapter. So he shall not be prosecuted under this chapter, under this condition. So if you can go through the section 141 of Negotiable Instrument Act, you will know under all these circumstances how a check issued by a company, if it is dishonored due to lack of funds, is treated, and what are the circumstances under which they are prosecuted and under which they are not prosecuted. So with this, we have completed all the questions from the fourth question, the four sub questions A, B and C and D. So if you like this video, do not forget to like and share the video. Thank you.